broadcast is now starting. All attendees are in listen-only mode.
So, welcome everybody to today's webinar on what to do when the investigator comes knocking, dealing with subpoenas. Just as a matter of some administrative information, the slides for today's session can be found on the Handouts tab of your GoToWebinar dashboard or at www.pileromazza, that's PILEROMAZZA.com/presentations. And we're also going to send everybody a copy of the slides and a link to the recorded session after today's session. I want to make sure everyone can hear us. If you can't, shoot us an email. By way of introduction, my name is Paul Mengel, and I am a counsel here at Pileromazza. I am a litigator. I've been practicing, oh my gosh, upwards of almost 30 years now. My practice in my career has primarily been in civil litigation. I am admitted in all the state and federal courts in the metro area, D.C., Maryland, Virginia. I'm also admitted in the United States Supreme Court and other jurisdictions around the country. I've tried cases around the country as we have clients nationwide, and also extensively practiced in the area of alternative dispute resolution and mediation and arbitration. And I'd like to have my colleague introduce himself now.
And good afternoon, everybody. My name is Matt Feinberg. Like Paul, I'm an attorney here at Pileromazza in our litigation department. And primarily my practice focuses on civil litigation, but I also am extensively involved in our government investigations practice, which includes Department of Justice, private litigation, and Office of Inspector General Investigations. Also, like Paul, I'm admitted in all of the metro area courts as well as various other courts around the country, including the Supreme Court of the United States. We're both happy to be here with you to answer your questions if you have any, and to bring you up to speed about the current state of government investigations and subpoenas in federal and state practice. So without further ado, I'm going to hand it off to Paul very shortly.
Okay, thanks, Matt. Just briefly about Pileromazza, as some of you may know, we're a full-service law firm, with offices here in D.C. and also in Boulder, Colorado, although Matt and I have not been able to lobby successfully to get offices out there. Probably best known as a firm that represents government contractors. For 25 years, we've done business in that area primarily, but we're a full-service firm. We have small business programs advisory services. We have a labor and employment arm. We provide business and corporate advice, intellectual property and technology rights, and as Matt and I have already previously indicated, litigation, which includes pretrial counsel. It includes actual trial work in the state, federal, and appellate levels, and also arbitration and mediation. Lots of our government contractor folks have dispute resolution provisions in their contracts that require arbitration, and we certainly have handled quite a bit of that as well. So let's get on to the materials. And by the way, folks, I just want to say we've got a lot of subject matter on our plate today. We're going to try to get through it as quickly as we can and cover everything that's on the slides, but this is a pretty big area. We are going to focus on subpoenas, and we'd be happy to answer any questions that you might have as we plow through this information. All right, Matt?
All right, so let's get started with why the topic of subpoenas is relevant today. As many of you know, the #MeToo movement took hold about a year ago, and since that time there's been a sort of changing of the guard in the way in government investigations and subpoenas have taken place. Some states are reporting as much as a 400% increase in sexual harassment and sexual assault claims. State legislatures, including Maryland and New York, for example, have implemented new sexual harassment laws, which include a watchdog component, so that individual organizations and the government itself can do independent investigations of industries that may see an increased rate of sexual harassment claims or complaints or lawsuits filed. There are also significant changes in employment discrimination laws and Department of Labor regulations over the last 6 to 12 months, which have increased the importance of government investigations and the instance of government investigations. The False Claims Act, which is particularly relevant for government contractors, those claims, the number of claims that the government has made, that a government contractor has made a false claim to the government, has increased pretty consistently over the last 15 years. You may have seen some news recently about public corruption in state and federal positions. And some of the government agencies that we have had the opportunity to work with have their inspector general's offices creating new task forces and, in fact, independent offices. For instance, the VA recently created the Office of Special Reviews this year to investigate a wider range of issues that could result in fraud or waste in the government. And these types of expanded investigations by the government are leading to more and more subpoenas issued to government contractors as well as companies in the private sector. Now, subpoenas arise out of many different types of legal situations, not just when the company is the target of a government investigation. And so we're going to touch on more than just government investigations in this webinar today. It's important to note that your company may receive a subpoena even when you've done everything right, when your T's have been crossed, your I's have been dotted, when you've acted above board at all costs. Subpoenas are simply a part of doing business, and you can receive one because a former teaming partner or a subcontractor has an issue with a third party. So it's incredibly relevant for businesses today to be ready when a subpoena lands on your desk in order to protect your bottom line and to make sure that you respond to the subpoena quickly and effectively to prevent future problems for your business.
Thanks, Matt. And you know, I don't think it's ever a welcome occurrence when a subpoena is received, but sometimes it seems particularly unfair when a company that's completely guilt-free of any sort of wrongdoing receives a subpoena for every single document that it ever had any sort of communication or anything to do with Company X, because Company X is the target or the subject, but nonetheless, Company Y is the one that's going to face all the expense. But as Matt said, it's kind of the cost of doing business in today's world. It just dovetailing on what Matt was talking about, and he mentioned that government investigations can be the source of a subpoena. They can emanate from the DOJ, whether the DOJ is investigating criminal activity related to an employee, criminal activity related to the contracting process, could be related to some sort of False Claims Act. There's any number of reasons these subpoenas can emanate. As he mentioned, the Inspector General for various federal agencies have subpoena power, and essentially any entity or investigative body, whether it's a government agency, whether it's a state agency, federal or state agency, whether it's a state attorney general, the Congress, or a state legislative body. And for example, we have a client that is involved in the election process, providing services related to elections. Our client received a subpoena from a commission that was created by the governor of New York to investigate corruption in New York elections. And that was one that I'd never seen before. But it just goes to show you that I think people think they generally come from courts or federal agencies, but there are all kinds of administrative and legislative bodies that create these committees or agencies, and then they empower them to issue subpoenas. So there's really virtually no area of corporate commercial activity that is not subject to receiving a subpoena. You can also have the direct litigants, whether it's the government or an individual. And as Matt mentioned, a sexual harassment case, a wage violation matter, you may receive a subpoena for all of your wage records, for your employment records. As I mentioned, False Claims Acts are particularly fertile grounds for the issuance of subpoenas, or topics that are specific to a particular industry. And if that weren't enough, third parties in just regular civil litigation. You could be a company that employs an individual who is involved in an ugly divorce, and you might receive a subpoena for all of his wage or her wage records, employment file. As it mentions here, employment matters. You often get those, and whether someone's filed an employment action from the agency itself or for the individual's attorney. And when a prime or a sub or a team member is involved in litigation, these individuals, now there's a difference between when an agency can issue a subpoena and when an individual can issue a subpoena or an individual's counsel. And generally on these third-party type cases, you have to have an actual case pending somewhere in a court if you are an individual or a lawyer representing someone. You can't just simply go to court and say, I want a subpoena. You have to have a pending case. Such is not the case with government agencies. All they have to have is an investigation, and they have very, very broad discretion. And we'll get into a little bit later about the scope of these subpoenas and the subject matter, but they have very broad discretion and a lot of power to really make your lives complicated when they decide to issue one of these subpoenas.
All right, so touching off on what Paul started to talk about, who exactly can issue a subpoena? And I'm going to be honest with you, the authority to issue a subpoena varies from state to state. As Paul mentioned earlier, a newly formed election commission was granted subpoena power by the governor. But generally, there are some well-accepted truths. First and foremost, state and federal officers are going to be able to issue subpoenas with very little restriction on their authority. An attorney general of a state or of the United States, or a state or district attorney related to an existing investigation can issue a subpoena. And when we say existing investigation, that means that, for instance, in a whistleblower claim, the whistleblower simply could make a complaint to a hotline, and once that hotline call is given a case number or an investigation number, the attorney general or that state or district attorney has the authority to issue a subpoena to investigate that complaint. The Office of the Inspector General can certainly issue a subpoena. Again, it needs to be related to an existing investigation. All that means is the Inspector General needs to open a complaint or open a case for the investigation. And finally, the Department of Justice can issue a subpoena, and that the only requirement there is where a grand jury has been impaneled. And typically that means a criminal matter. There are some investigations by the Department of Justice's civil branch that don't require a grand jury to be involved, and the investigation alone is enough to issue a subpoena. In private litigation, an officer of a court, such as a judge, a court clerk, or in some state and federal courts, in fact all federal courts, an attorney in active litigation may issue a subpoena directly to a third party or to a litigant. And finally, a legislative body, although these are much more rare, you may get a subpoena from a state legislature or from the U.S. Congress, from a committee of the U.S. Congress. If you're involved in government contracting, this is certainly a possibility, particularly if the Congress is investigating the way in which a certain type of government contract is being implemented. For instance, perhaps if you work heavily with the EPA, the Environmental Protection Agency, a subcommittee of the Senate or of the House may subpoena government contractors working for the EPA to examine how EPA contract administration has proceeded in the last 3 to 5 years. Again, that's more of a nuanced subpoena request, but you're more likely to receive a subpoena. The most likely you're going to receive a subpoena in third-party litigation where you've either been sued, your company has been sued, or you are tangentially related to a lawsuit between, say, a subcontractor and an employee, or something like that.
If I could just follow up too, Matt, I'm a little bit longer, or considerably longer in the tooth than Matt is, but I can remember when the state, certainly in the Commonwealth of Virginia, when the rules changed, you used to have to go down to the courthouse and you had to go to a clerk, or usually a clerk, and you would have to stand in line, and the clerk, you would have to tell the clerk, you'd have to fill out the forms on paper and tell the clerk why you wanted the subpoena, and the clerk would have to stamp it or go get somebody else to sign it. But these things really changed when they started empowering attorneys to just issue them. Some people think that's a good thing. I certainly do, because it makes it a lot easier for us. Some people think it's a bad thing because it makes it a lot easier for attorneys to issue subpoenas. And we can literally sit at our desk, call up the form on the court website, print it out, sign it, and send it out, and that's an official subpoena. Whereas you used to have to go through all the fancy steps of getting the seals on it and the stamps on it and going down to court. So it's really changed, I think, just the sheer volume of the subpoenas you get in practice today. Alrighty, and so moving on to what kind of subpoena that you might receive. Subpoena, of course, is a word that derives from the Latin, and we have two more Latin phrases in here, and you know how we lawyers like to use Latin because we like to think it makes us sound like more intelligent, but I'm not sure about that. But there are different kinds of subpoenas, and they ask for different sorts of things. And a lot of people think that you just get a subpoena and it's going to require document production, but there are various types of subpoenas, and the first thing you need to do is take a look at it and see what they're asking for. The first type and the most commonly received type is a subpoena ducis tecum, which is to produce documents. And these things, or tangible things, and while primarily you usually produce documents, it also, these subpoenas permit testing. For example, if it's involved in some sort of products liability case, or the examination of laptops, or the examination of the scene of the crime, whether it's a factory, whether it's a damaged automobile, whether it's a site where someone says there's toxic substances. But a subpoena can command that the recipient allow someone to come on their land, allow someone to see all their documents, to see their laptops, to see their equipment. And that entitles the recipient to not only examine the material, but in the terms of documents and electronically stored information, to review that material and to copy it. And as we note there, documents, when I started out practicing, meant paper. And as we all know, it doesn't mean that anymore. The electronically stored information has exponentially, it's indescribable how much it has exponentially increased the scope and the amount of material, as you know, from maintaining your own businesses, that is acquired and just accumulated on a day-to-day basis, whereas someone might write a letter once a week to a subcontractor or a telephone call 20 years ago. Now there might be 50 emails a day. Each one of those is a document. Each one of those is subject to production. So it is all of the electronically stored information that is relevant to the subject matter of the subpoena is discoverable, which has phenomenally increased the cost, unfortunately, to folks like you in responding to these things. Sometimes they are also, these document request subpoenas, or ducis tecum request subpoenas, are presented with a command that the custodian of the records appear. So, as you know, if you receive one of these, you get a subpoena and it says, by X date, you will produce the following information. There'll be a list of information they want you to produce. It'll also sometimes say, and you will appear and testify as to the authenticity. They can command a person to show up and testify, either as to the authenticity of the documents, or they can command you to testify and provide a deposition, or they can command you to come and provide testimony at a trial. So there are various types of powers that these subpoenas empower the server of the subpoena, and what it requires you to do in response. In my experience, the trend now is to not require the personal appearance of the individual or the guardian of records. Generally speaking, even if you get a subpoena to ad testificandum, or it's a subpoena to appear and testify about the authenticity of the records, usually the people that send the subpoena will, in lieu of a personal appearance, accept the provision of the documents at a certain place by a certain time. And that sometimes is also subject to negotiation. And we're going to touch on the negotiation with the server of the subpoena a little bit later. And there's two primary ways that you get them. You can get them by mail or in person. As Matt touched on, there's different state courts and federal court rules. Every single jurisdiction, except for the federal rules have a general rule with regard to subpoenas in all federal courts, but every state has different rules. And there may have different rules as to service, and we'll touch on that later on checking on whether service is good. But you usually get them by mail or certified mail, or a process server knocks on your door, or your registered agent might receive them either electronically or by mail. Or, unfortunately, you might also get a knock on the door or a kick in the door by the Department of Justice, who just simply serve a warrant and seize your documents.
So how much information can a subpoena request? Unfortunately, the short answer to this question is a lot. A subpoena can ask for anything relevant to the specific topic for which the subpoena was issued. So for instance, if you are a third party, and we actually had this a little bit earlier this year, a prior employer, client of ours, received a subpoena for all of the employment records related to a certain former employee who was at that point suing a subsequent employer for sexual harassment. Now, the production of those documents is probably quite small in the long run, but that is on the small side of the production. Documents that could be relevant to a subpoena may be number in the hundreds of thousands or even millions. We actually just finished a document production on behalf of a government contracting client that had 4 million documents that we had to produce to the Office of the Inspector General. So what exactly is relevant? Relevance is certainly something that is directly relevant to the issue. So if there's a question about whether a company is properly identifying itself as a hub zone company, for instance, all documents related to its hub zone certification and recertifications and any hub zone contracts would certainly be relevant. But in addition to that, documents that are relevant include any other document or tangible thing that could lead to the discovery of relevant evidence. And in that case, we're talking about a wide range of information that goes well beyond perhaps what you feel is reasonable. But the government, again, has wide authority to ask for basically whatever it wants, and there are some limited ways to restrict the government's access to that information that we're going to talk about in the next couple of slides. It's important to note, and this isn't on the slide, that when you produce documents in response to a subpoena, your custodian of records, and that's generally considered the person with authority to speak on behalf of the business who has participated materially in the collection of the documents, must certify that they have produced all responsive documents that are in the company's possession, custody, or control. So that might mean all of the emails from a specific individual who's named in a subpoena, but it also might include all employees related who have conversed with that individual or with a company that is named in a subpoena. And so that's why it's very important to understand the scope of a subpoena and the scope of an investigation from the very beginning of the subpoena process, because we could be talking about hundreds of thousands of documents. Some of the types of information that are sought in a subpoena are hard copy documents. In the government contracting world in particular, a lot of documents are exchanged digitally, either through email or through one of the online portals. Those documents are subject to production as well. Emails, of course, are a huge topic of, are a subject of subpoenas, and often the government will ask for both either a hard copy or digital copy of a readable format, as well as the native file. And when I say native file, I mean the actual document that sits in your hard drive or in your archives, employee email archives, that wouldn't be readable if you just tried to print it out as a PDF, but that with certain software that is now available to attorneys and to the government, we'd be able to read the email as if it showed up in your Outlook. Of course, employment files, often with sexual harassment cases, wage claims, are going to be the subject of a subpoena. We might be talking about internal memoranda between executives and employees. And as Paul mentioned earlier, the government can request hard drives, laptops, or digital stores, maybe flash drives or CDs that the company has produced to keep its documents on for prosperity's sake. The government can request documents into the reasonable past. So we've had documents, requests going back to 2012, 2009. Sometimes we've had document requests that go back into the 1990s. the amount of documents and the type of documents you're going to have to produce, it has to be reasonable under the circumstances. So if there is a request for documents from the 2000s and your company is not, it wouldn't be reasonable for your company to sustain the document retention for now 18 years later, the government isn't going to penalize you for not being able to produce those documents. We're going to talk about this a little bit later, but if the document request goes back to 2016, the government is not going to look fondly on you if you haven't retained the documents and cannot produce them.
I just want to chime in because we don't have these attached, but when Matt said, I think people sometimes have a problem with the concept of relevance, lay people in particular, and as he indicated, and as he described perfectly well, that the government casts a wide net. But I just happened to bring to this webinar an example of one that the Department of the Army issued to one of our clients. I'm just going to touch on for a couple of seconds because our client received this subpoena, and Matt was talking about the scope. But just for an example, this says documents required, all documents that, and it says all final and non-identical drafts of the contract, all announcements, advertisements, solicitations, and requests for proposals, all announcements, advertisements, solicitations you drafted, all documents related to your effort to establish offices, documents to show the price charged to the government, quoted, estimated, paid to subcontractors, all documents relating to the selection of subcontractors, teaming partners, and personnel, bids, all mailing, shipping, and tracking documents, documents related to the negotiations, minutes, agendas, and attendance of board meetings, accounting records to show the date and amount of every payment you received, personnel records for all the employees, memoranda, emails, and other communications between any of the entities, documents that show all their income, all their sales. I mean, that's just 14 of the 25 categories that were in the subpoena. So sometimes it's just incredible the scope of these things. And as Matt said, even with a small or medium-sized company, that can be hundreds of thousands of documents.
Oh, so what can you do to protect yourselves from these overwhelming scope of the subpoena or potentially from fraudulent or improper subpoenas served? So first, we're going to talk a little bit about what you can do before the subpoena arrives to protect yourself. The most important thing you can do is create a document retention policy and follow it. And that's critical because if you don't have the documents to provide to the government or to a third party when the subpoena arrives on your desk, you're more likely to be called into court or called into a deposition to testify about why those documents no longer exist, why you did not retain them, why you thought it was okay to destroy them, or about the specific facts that those documents would have shown. So in the long run, producing documents in a subpoena is better than having to testify in court. So we recommend that government contractors in particular retain documents related to their government contracts for at least 6 years. And the reason that we do that is because the government may make a claim against a contract or related to a contract for 6 years after the contract has concluded performance. Now, in the private sector, you may not need to retain your documents as long, but that's going to be an industry-specific inquiry. In many states, such as Maryland, where I do a lot of practice, the statute of limitations on most claims, including breach of contract, is 3 years. So if you're in the private sector and you might have potential litigation in the future, you might want to keep those documents for 3 to 4 years to make sure that you have the documents to produce and the documents to refresh your recollection in the event that you are asked to testify in a deposition or in a court proceeding. You also want to create an internal communications policy and follow it. And what I mean by that is you want to make sure that you are reasonably regulating the types of communications that employees are sending to other employees. I cannot tell you the number of times I've done a document review in response to a subpoena and a joke or particularly inside jokes or political humor, inappropriate emails that have been exchanged between employees who are friends, they sort of gum up the works and don't make the company look so great. In addition, There are emails where executives or managers might show some frustration for a contracting officer or for an employee of the government, and they say something derogatory or critical of those individuals. All of those documents are likely to be produced in response to a subpoena because of the broad scope. So we like to instruct our clients that if they could implement communications policies and try to enforce them where reasonable, to make sure that nothing embarrassing is produced to the government or to an OIG or to another third party that could make the company look bad. You want to train your trainers and manage your managers. Trainers and managers are the boots on the ground. They're going to know or perceive when a future problem might arise based on present conditions. So for instance, I represent a lot of restaurants. The restaurant industry is rife with sexual harassment claims right now. It's a very difficult workplace for owners of restaurants to manage the conduct of their employees, particularly because it's not a desk job. And they're usually not on computers. It's day-to-day interaction, and it's often young employees. So you need to train your trainers and manage your managers to identify problem areas before they turn into big problems. Because when the big problems have arisen, when there's a claim for sexual harassment or a claim for not following a termination policy or a discrimination matter coming up, it's better to know that those instances have existed and that you've responded correctly in order to prevent the subpoena from coming your way in the future. You also want to make sure your resident or registered agent is aware of his or her responsibility. Some larger companies will have a third-party process registered agent to receive service of process. Others have executives or secretaries or treasurers who act as the resident agent for the company. And it's important that when that person receives service of process, whether it be of a complaint or in this case a subpoena, it's important that they react very promptly and that they know that the person who is most likely to speak to the general counsel or to outside counsel about that subpoena receives the subpoena as soon as possible. Sometimes there are deadlines in the subpoena for producing documents, and sometimes due to problems with service or delays on the government's end, you may not receive a subpoena until a day or two before the response is due. It's important that your attorney or whoever is going to be communicating with the government on your behalf receives that subpoena right away so that they can negotiate an extension of time to respond to that subpoena. And finally, you want to develop a relationship with an attorney in advance. Time is of the essence once the subpoena has been issued. So if you have a subpoena, or an attorney rather, on call at any given time if something arises, it's best to be able to call that person right away, say, we've received a subpoena and we don't know what to do, or we need you to handle this for us. And it's best to have that existing relationship so that the attorney knows your day-to-day practices and knows what exactly they can expect from the subpoena process.
And just sort of following up on the related subjects, what can we do to protect ourselves, and what you can do once you receive a subpoena? As Matt said, and I'd like to elaborate on a little bit, as I mentioned earlier, each subpoena has its own usual time response requirements, processes for asserting objections in court. For example, if it's a federal court subpoena related to an ongoing federal case, you're going to have a specific amount of time by which, if you believe that the scope of the subpoena is overly broad, or if you believe the subpoena is requesting privileged or otherwise undiscoverable information, you have X amount of days to file a formal objection or a motion to quash the subpoena in court. Similarly, with agency and other related, let me back up a little bit. With some of these agency-issued subpoenas, your ability to protest the scope might be more hinging on your skillfulness in negotiating, or your attorney's skillfulness in negotiating, because there are less reliant on court processes to narrow the scope. But the point being that as soon as the subpoena issues, a clock is running, and your right to object to the scope or to contest the subpoena, whether it's whether you believe it was defectively served, whether you believe it has other defects that we can legally object to, whether you believe the scope is overly broad and burdensome, or seeking information that's not reasonably calculated to lead to the discovery of admissible evidence, your time is limited to raise those objections. So you must be diligent and act quickly, either on your own or giving it to an attorney for immediate response. In our experience in responding to subpoenas, obviously, we try to cooperate with the investigators. Sometimes we have small companies that are 2, 3, 5, 6 people in the home office. And as I touched on when I just listed some of these things that this other subpoena was looking for, it's overwhelming. I mean, it can completely disable the office of a small company in just trying to respond. It's a full-time job. If you had to provide all of the requested documents in some of these extremely broad subpoenas, you would have to basically shut down your performance on the contract, because it would be a full-time job if you had to do it within 10 days. So it's really important to reach out to the investigator. In our experience, especially on the federal and the agency type investigations, some of these things go on for years, and you can negotiate a reasonable extension. You can negotiate, if you can't negotiate a narrowing of the scope of the subpoena, you can negotiate what we call a rolling production. In other words, Mr. Investigator, it is impossible for my company to provide all the responsive documents within a month. What we can do, though, is devote enough folks to do it where we can provide a rolling production. We'll provide as much as we can get to you in the next 2 weeks. And then 2 weeks after that, we'll provide another production. So you can not only negotiate the extension of time to provide all the documents, but you can usually negotiate a rolling production. And you see the next bullet point, ensure the subpoena is valid and enforceable under existing law. I touched on that already. There may be a defect with regard to the service of the subpoena. I mean, people that are particularly in sometimes in lawsuits as opposed to federal agencies, they usually have their ducks in a row. But sometimes with lawsuits, a lazy lawyer will just put it in the mail and send it to you. And in that particular state, that might not be good service. And frankly, you don't have to respond to it. So you need to check to see if the service is appropriate, and whether the subpoena in the scope and in the service and the nature of the subpoena is enforceable under the law. Again, as I mentioned, you can negotiate a reduction in the volume of the information requested. I mean, these things are sometimes so incredibly extensive. You can go to the negotiator, or you can negotiate with the server of the subpoena and say, look, what are you really getting after here? What is your goal? What are you really looking for? Let us give you what we think is most relevant to what you're looking for. And if you don't find that is sufficient, then we can go on to some of these more tangential areas. But how about we give you A, B, C, and D to start with and see if that satisfies your inquiry. So you can usually negotiate, because they're going to cast a wide net, and sometimes you can narrow the scope of that net by a negotiation. Again, as I mentioned, you can, if you have a legal reason why the scope is too broad, you can seek a protective order in court, which would protect the production of the information you believe is privileged or otherwise not subject to discovery. You can object or file a motion to quash, similar mechanisms. But again, as we emphasize, there is a time running for that. And if you're out of time, especially in a court like the Eastern District of Virginia, the rocket docket, if you're out of time, you're out of luck. And as I touched on at the very beginning, you can often negotiate not appearing in person to deliver the documents or provide personal testimony. You should bear in mind, as we note in this slide, that almost any subpoena you receive from a government investigator will require confidentiality. They usually state that in the document. When you receive some of these subpoenas from the government, they could be 20, 30 pages long. They may have 8 pages of instructions. They may have 10 pages of definitions. And then they may have 10 pages of what they're looking for attached to that. But in there, oftentimes, is a warning to you that, especially if it relates to criminal investigation, you need to keep the existence of the subpoena to yourself. The last thing you're going to need is to have someone from your company blabbing about receiving the subpoena. That gets around somehow to the subject of the investigation. The next thing you know, you're facing a charge of interference with the investigation.
All right, so what should we do first? And perhaps this is a shameless plug, but first and foremost, you've got to call your attorney. And the reason that you need to call the attorney first is some of the issues that Paul touched on a few minutes ago. Attorneys with experience handling subpoena responses and government investigations are best equipped to protect your rights. They're going to notice the flaws in the subpoena, whether there was a service issue, whether the subpoena itself is invalid or fraudulent. Recently, we have received several completely bogus subpoenas, or I should say our clients have received bogus subpoenas. But of course, the client believes that they're accurate and valid, so they send them to us, and it turns out they don't have a seal, and they were served simply by a disgruntled employee who wants to threaten the company in an ongoing dispute over a termination, something along those lines. So the attorney is going to have seen a similar subpoena before, is going to know when it doesn't meet the requirements of the rule, and they would be able to stop the subpoena from impacting the business. The attorney is also going to know whether protective order, objection, or motion to quash is appropriate. And frankly, in some states, you only get 7 to 10 days to file those requests. So it's important to get the attorney on the horn immediately so that they know that the situation exists and that their response is required quickly. Now, practically speaking, a government investigator or an attorney issuing the subpoena is less likely to try to take advantage of another attorney and is more likely to offer professional courtesies such as extensions of time. Now, this isn't fair, but it's typically the arrogant attorney, and Paul and I would probably fit in that category just as much as the rest of us. We believe that we can run over an individual who's representing themselves or an individual who's speaking on behalf of a company because they won't know the rules as well as we do. So it's important to get an attorney on the line so that your attorney is speaking to the person who issued the subpoena, where they're probably going to get a little bit more of a professional courtesy, particularly with the scope and the deadlines for responding to the subpoena.
And with regard to those deadlines, just to briefly follow up, I've seen situations where subpoenas have been presented or dropped off by a process server. They sit on somebody's desk for a few days, or if service by mail is acceptable in a particular jurisdiction, it gets mailed, and the next thing you know, even though the subpoena and the letter says you must object within 10 days of the issuance of the subpoena, by the time it gets around to the person responsible for the response, there's 2 days left. So again, it's really important to not be dilatory in formulating your response. Moving to the next slide, what should we do second? And this is important. You keep the existence and the scope of the subpoena on a need-to-know basis. Now, obviously, you're going to have to communicate with your folks that have documents that are responsive, your management folks, your people whose emails are going to have to be searched, but you really don't want to go public with a subpoena, as we touched on earlier. And you want to also try to maintain the confidentiality of any communications. I doubt anyone on the line with us would have such an issue, but quite frankly, sometimes the recipients of the subpoenas are the subjects of the investigation, the targets of the investigation, and the government believes, or the IG or the Department of Justice believes, that the client has done something wrong. The last thing you want to do is a panicked manager hold a meeting with his employees and say, okay, everybody, we've got this problem with the ABC contract, and I want you in X, and this is the issue and Y. And the reason you don't want to do that is because those conversations are discoverable. And so whatever the panicked manager or the panicked company president says in the presence of these employees, when the investigator comes around and maybe subpoenas one of these employees, they're simply going to ask him, well, what did Mr. Jones say about this investigation? Or what did Mr. Jones say about the issue with subcontractor Y? And there's no privilege. And that employee is going to have to, as much as he or she wouldn't want to, spill the beans on whatever the president or the manager said. So it's best to take a deep breath. Nobody likes to get these, but to keep it on a need-to-know basis. And if you're going to have communications with management, to the extent you can, have your attorney on the line to protect any attorney-client privilege that might be in place. Now, we really don't have the bandwidth in this particular program to go into detail on attorney-client privilege. That's enough for 2 or 3 webinars in of itself. But in brief, when looking at the attorney-client privilege with regard to communications between the company employee and an attorney, the communication needs to be involving information necessary for the attorney to provide legal advice to the company. The communication and the information relate to matters within the employee's scope of employment, and the employee making the communication was aware that the information was being shared with the attorney in order to provide the company with legal advice, and the communication was kept confidential and not disseminated beyond the employees who needed to know. So, again, this is not the proper subject for water cooler conversations, especially and most especially if you think the company might have any concerns or issues related to the underlying subpoena. It's critical to maintain the attorney-client privilege as much as possible.
All right, so in addition to getting your attorney on the line, in addition to all of the other things that we've told you to do first, here's another thing you have to do first. Cease all document destruction procedures pending resolution of the subpoena. As I mentioned earlier, we were talking about a document retention policy of 3 or 6 years. If you may have email or digital file archives that automatically delete at a certain period of time, or you may have a shredding company that comes to your office once a month and grabs the next box on the shelf, you want to stop all of those processes right away. Investigators and courts may draw an adverse inference if documents are destroyed after the receipt of subpoena, or in some cases after notice of a claim. So, for instance, if an individual files a sexual harassment claim with the EEOC, you are given notice of that. Once you receive notice of that claim, even though you haven't received a subpoena yet, you want to stop your document production of any documents that might be, document destruction of any documents that might be relevant to that claim. So when you receive a subpoena, your best practice is to stop all document shredding and digital deletion of documents because, again, the scope of these subpoenas can be so wide-ranging. You want to assemble your internal and external, if needed, team for the response to the subpoena. And the internal team is generally going to be 1 or 2 management level employees, a point of contact for either the attorney or the investigator or the attorney handling who's issued the subpoena, and inevitably someone in your IT department. Sometimes that person, if you don't have an IT department, may be external to your business. They're going to be the people best equipped to producing the hundreds of thousands of emails that may be requested in a subpoena. We've touched on this before. You're going to want to cooperate with service and the investigator. A happy investigator is more likely to provide accommodations such as extensions or a rolling production. And if you show interest in helping the investigator get to the problem that they're investigating, they may be more likely to limit the scope of the documents in order to touch really on the issue as opposed to the tangential issues that might be included in a subpoena. And then the last 3 things on this slide really are for an attorney's benefit who might be representing you and responding to the subpoena. You want to identify the scope of the subpoena and the number of documents at issue. For instance, it might be one thing for you to produce an employment file for a past employee. That might take mere minutes. But if you're asked to produce every document related to a government contract that you've been performing on for 5 years, and you have hundreds of thousands of emails related to that, you need to have an idea of how many documents you're going to be producing so that you know exactly how much time you're going to need to produce it and how much time your attorney might need to review any of those emails for a potential attorney-client privilege. You also want to help your attorney determine the subject or the investigation of the subpoena. And sometimes this can be a very difficult process. Sometimes not. Last year we received a subpoena to one of our clients that asked for all documents related to a very specific firm that had been a teaming partner many years prior. It is very clear from that subpoena that the subject of the investigation was that former teaming partner. But sometimes you'll receive a vague subpoena that simply asks for documents related to a topic or to a contract. It can be difficult to determine what the subject of that investigation is. But again, the people who performed on that contract are going to be the ones who know the subject and may understand why the government is investigating. And by talking with an attorney and knowing who the person requesting the subpoena is or issuing the subpoena, you might be better equipped to know what the subject of the investigation is and what sort of privileges or defenses may be available to you. And finally, you want to help the attorney identify areas of potential privilege. That could mean, for instance, if there was a claim of wrongful termination or workplace discrimination, you may have a number of communications with an attorney previously about this individual employee's claims of discrimination and those contacts with the attorney would be privileged. So you want to be able, again, as the boots on the ground, to be able to help your attorney help you in the long
run. This next subject, I mean, this sounds like a hypothetical, but I got to tell you, given the scope of some of the subpoenas that we've seen and the relative size of some of the companies that we represent, this is a legitimate question, and because your folks that are sitting there tapping out these emails and everything is related or possibly related to one of these issues, there are, as we said, could be, even on the smallest of cases and the smallest of issues, there could be hundreds of thousands of documents. And on something like a construction contract investigation, there could be hundreds of thousands of documents. And so I think it says responding to a subpoena can be an expensive and time-consuming endeavor. I think it is an expensive and time-consuming endeavor unless you're able to limit it or avoid it altogether. And this is particularly the case if you get the subpoena as part of an investigation by the DOJ or the IG. In all candor, most of our clients simply can't afford to have us at our billable rates examine every single document that is responsive. I mean, some clients can, some clients can't. But again, there may be 300,000 responsive documents, and the question is going to arise, how are we going to manage this cost? How are we going to pay a lawyer to eyeball all these documents? So you need to have, as Matt talked about earlier, someone in-house that's competent to corral these documents, to organize them, to segregate ones that might theoretically be privileged by running word searches or by otherwise organizing them so that they can be presented to an attorney or to a paralegal at the law firm that bills at a lower rate than the attorneys. But sometimes simply companies are just going to have to say, take it on faith and turn them over and not be able to have them examined by an attorney. And that's just the way it goes. But even if that's the case, you should at least try to ferret out, figure out what your budget is, and ferret out the documents that you think might be problematic, might be privileged, and at least get someone at a law firm who can hand that task down to someone that's either a paralegal or a lower level associate that bills at a reasonable rate to review. Because the last thing you want to do is turn over documents that expose you to some sort of issue without getting counsel on it first. We've touched on a couple of times trying to negotiate the limited scope for your response, and we've had a lot of success in doing that. Sometimes it can be done, sometimes it can't, but that is definitely a priority. And again, as I said, you've got to weigh the cost and risk to determine how much your attorney can be engaged, and whether some or all of the production can be handled in-house. I also mentioned the rolling productions, which spread the cost out over time. We can do X amount of hours this month, and if you've got a good relationship with the investigator, you've been the lawyer or the individual of the company has been courteous and responsive and agrees to fully comply, the rolling productions can spread the pain out over a longer period of time, especially companies that rely on payments from the government on contracts to come in to meet payroll and other obligations, and frankly don't have a whole lot of money sitting around to give to lawyers.
All right, so what happens after you start producing the documents? Subpoenas in a government investigation are usually the first step. You might receive subsequent subpoenas for additional records if an investigation leads the IG or the DOJ down another path. You might be asked to give a recorded in-person interview. The DOJ or OIG may perform an audit of the contract. You may be asked to appear in person for a deposition, whether to provide facts to the government or perhaps just to authenticate documents. You may be asked to do a presentation to the government on a contract-specific issue, or you may be asked to give in-court testimony. Therefore, it's critical to take subpoenas seriously from the moment they are received in order to prepare for or prevent further impact to your company's bottom line. Now, when you're not talking about a government investigation, when you're talking about, say, a third-party subpoena or where you're a direct litigant and or one of your employees is a direct litigant, you may have a smaller scope of responsibility. The subpoena and the production of documents may be the only interaction you have with that litigation. Often you can sign a certification as to the authenticity of the records, and the scope of your work may be complete at that point. The important thing, though, in any situation where you've received a subpoena is to debrief with your attorneys to locate any areas of concern for your business after the documents have been produced. Sometimes this will be when I said internal communication requirements or internal communication rules for your business. These are the types of things we have to counsel clients on all the time. You also want to maintain that attorney-client privilege into the future, because occasionally you'll have a situation that is ongoing. You may uncover, say, a wage payment violation or instances of sexual harassment in the production. You want to be prepared to for any future investigation or future suit that arises out of that conduct, and you already know that you have the documents. In addition, you may have to provide supplementation of the documents shortly afterwards for use in a trial or other hearing. Now, before we close things up and finish, we have received a couple of questions, and so we want to touch on those briefly. If any of you have any additional questions and we haven't answered something that you have a question about, please feel free to send us a quick question, and we'll try to address it really quickly with our remaining time.
And if we can't get to it today, you see on this last slide both of our emails. I mean this. Don't hesitate. Shoot us an email. You've got a question, whether it's in general or specific, feel free to send us an email. We'll get back to you. I'd like to take a quick look at this, and Matt, chime in. This questioner says it sounds like the bulk of the information you're giving is related to government investigators. Well, it is, because primarily, frankly, most of our clients in this firm are related to government contracts, but we certainly get lots of subpoenas in general civil litigation. And it sounds like this is what this is getting at. Specific to a third-party attorney in a breach of contract claim, are the guidelines the same for the responding party? The rules apply across the board, really, no matter what kind of case it is or what kind of investigation it is. A subpoena is an order from a court. It is a command to produce the documents, and failure to respond to that command subjects the responding party to contempt of court. So what if they claim, truthfully or untruthfully, that they do not have the requested documents? How would the court know that this is true, and what, if anything, could be done to compel production? Well, unlike a request for discovery, which if it's not complied with, you can file a motion to compel, a subpoena is an order to compel. If you have information that leads you to believe, or in good faith, that the documents aren't being produced, or you have evidence of that, then you certainly would bring a motion before the court to enforce the subpoena and to hold the other party in contempt for not producing it. I doubt if an attorney would do this, because an attorney responding to a subpoena and willfully producing, or not, I should say willfully hiding or not producing responsive information, would subject that attorney to sanctions and possible loss of his or her bar license. But an individual might try to hide documents. Unfortunately, the only thing you can do is, if you believe someone is not producing the documents that are responsive, and you have evidence of that, you have an email that they didn't produce, you have correspondence that they didn't send over in your inbox, you attach that to a motion to compel, and the court will bring that person into court and say, why shouldn't I hold you in contempt for not producing responses to the subpoena?
There's another option that you could implement if you believe that documents haven't been produced that do exist, or if a litigant or a responder to the subpoena says that the documents do not exist. If you're represented by counsel, or even if you feel comfortable doing this yourself, there's nothing that stops you from taking what's called a deposition of that individual and have them explain, for instance, if they ever had the document in their possession, whether they destroyed it or whether it was lost, why they don't currently have it, if that's a document that, like we talked about, is within, say, a 3-year period, or even a 6-year period if it's a government contractor, they're going to have to account for that document. If they're not a litigant, there are minimal sanctions that a court could impose absent proof, at least reasonable proof, that that document was intentionally destroyed. If the person is actually a party to the case, however, the motion to compel practice does apply, and you would be able to receive sanctions or potentially an adverse inference from the court in the event that there was a destruction of the document. So I hope that answers your question. I know that that's our presentation today did center a lot on government investigations, but generally speaking, the practice of responding to a subpoena is going to be very similar, whether it's a subpoena issued by an OIG or the DOJ or by a third-party attorney. Like we mentioned earlier, however, the ability for you to object to a third-party subpoena is a little bit, you have a little more power objecting to a third-party subpoena than you do to a government investigator.
All right, folks, I'm afraid we've run out of time. This is a broad subject area, and we've tried to cover it as much as we can. As I said, if you have any additional questions, feel free to reach out to us. You have our email addresses, and as I indicated before, the documents, the materials will be provided. Thank you very much. We hope this has been helpful, and we look forward to speaking to you at another webinar from Polaro Mazza. Have a great afternoon.
All right, now we're muted. I have what to do.
Okay, he'll take care of it.
It's good. Now we just let that. How do I press?